Hello everyone. We're meeting here at the Law Faculty of Vilnius University to discuss the changing nature of the judicial role in our societies. What are the expectations of courts? Should we assess the quality of court decisions? My name is Donatas Murauskas, and today I talk with the exceptional guest, Professor Charles Szypszak. Professor Szypszak is Albert Coates Distinguished Professor of Public Law and Government at the University of North Carolina at Chapel Hill School of Government. His expertise includes real estate law, public institutions, public administration. Welcome to Vilnius, Professor, and thank you for visiting us.
Thank you. It's a pleasure to be here.
Today we're facing polarization of worldviews on both sides of the Atlantic. The views expressed by the society push us for new extremes. At the same time, courts are dealing with cases related to social challenges. And here we witness that courts, especially the Supreme Court of the United States, are viewed as one of the central actors in the heated debate between the political opposites. You may ask, are the courts here only hostages of a political debate, or are they driving force of this debate? Why do we witness the United States Supreme Court as such an important political actor in the United States?
You're absolutely right that over time the court is increasingly being perceived in that way as partisan and divided, especially on the momentous social issues. It's a little bit of a misperception at the beginning because most cases that the Supreme Court considers, more than 100 per year, there isn't that kind of disagreement. Different groups of judges agree with each other, approach to the cases analytically in a way where no one would detect any sort of partisanship. It's really only the cases that attract the most public attention where the public perceives the justices as having that type of orientation. They don't so much drive the debate or the outcomes as they do reflect the trends that are already happening within society. And some of the more recent notorious cases that attract the most attention, while they become lightning rods for criticism by those who disagree with it, often they really just align with the way courts and policies have been moving anyway. I'd say that in recent times, the notorious Dobbs case involving abortion, other cases like that, they get the most attention because they're the most hated issues. But they've already been policy issues that have been working through the political process. So it's a perception more than it's a reality, I think.
But if we discuss similar issues in the context of the European legal framework, there would not be so many references to the European courts. Do you think there could be explanations why it is exceptionally more viewed in the United States as the United States Supreme Court is at the edge of the debate in comparison to the European highest courts?
Certainly, you know the European experience far better than I do. I would say that since about the 1960s, the court has made decisions that the public has associated with policy choices. Really back to the 1965 case of Griswold versus Connecticut involving rights to medical advice about contraception. The public perceived that case as creating a situation where the court was declaring rights that weren't explicitly in the Constitution. Those rights were coming from being announced by the court and could not be found in the text of the Constitution. So the public begins looking more and more to the court as the source of that when they're not getting the same results through the political process and the legislative actions. The court has a sort of super legislature, and that's, if that's happening and you agree with what the court is deciding, you're all for it. You want the court to be that way. the years, I always told my students, if you're so happy with the way the court has created these rights or announced these rights, you also have to be happy with the idea that it's the court that's doing that, even when it's not what the legislatures or the Congress has done. So if the composition of the court changes, and those decisions are no longer the ones you agree with, as a process matter, you still have to say it's okay for the court to do that, to make that final decision. And that's really where the disagreement among the justices comes, as what you think a court should really be able to do.
Mm-hmm. We're really here talking about the role of a court in the society. And here, especially in the civil law tradition, we tend to identify the judge's role between the extremes. Here we have the judge who is solely applying the law, and on the other hand, there are some requests for judge to go beyond the formal boundaries of the law. And this discussion is actually highlight what is talked about the highest European courts. And it also reflects the ongoing debate in the US between originalists and the proponents of the living constitution. Could you tell us some explanation of what the originalists are and what the proponents of a living constitution are fighting for?
And that's really the right question to ask as a follow-on to what we were talking about just a minute ago, is how is the court being perceived and what is its role? And so the difference is, goes right back to the beginning of the role of the Supreme Court. The most famous Supreme Court case in the very early times in American constitutional law was Marbury versus Madison. I'm sure you're familiar with it. And it was Justice Marshall who decided that when a case comes before the Supreme Court and it involves a constitutional question, the court will decide what the Constitution means, and if it conflicts with a statute, the court. Now, the point of that is the court is looking at a conflict between a statute and the Constitution, and it's logical. If the court has to do that, it will choose the Constitution. For many decades, that's the limited role that the court played. The real turning point came in the 1950s, 1960s, when government had expanded. Its actions in American society had expanded. It was doing all sorts of things that the framers never envisioned the government would do. If you think of the original role of government as being very limited and constrained, the court doesn't have a role really in declaring rights to protect what the government's doing. But when the government's doing all sorts of things, like regulating access to contraception, regulating abortion, then you have to consider, well, when is the government going too far? And that's where the disagreement comes. Some justices, the originalists, say that what we are doing, as you said, is interpreting the Constitution, interpreting the statute. We are applying what those who chose it in the legislative process wish to express. In the Constitution, it was the people themselves who adopted the Constitution. So what we're trying to do as a court is understand what they intended. That's the originalism. Another version of that is textualism. Slightly different way of looking at it. It's not so much that you're trying to figure out what was meant as you're just sticking to what's written and not being creative with what's written. And that allows for you to update the language a little bit more. So the originalist sees the court as very limited in the process, not as sitting and looking at what the legislature is doing, deciding whether there should be more rights or more protection, but as saying what was intended, because if the people want something else, it's for the legislative process. It's for the constitutional process. It's all of the people who make that decision, not a court of 9 individuals. Now the argument for the so-called living constitution is, well, that's fine, but for one thing, it's the majority that controls the process of enacting constitutions and statutes. And that doesn't protect the minority. And we as a court are here to protect everyone's rights and not just be in favor of the majority will. So we need to be a little bit more careful that the originalists slaveholders in the original Constitution, well, we're not going to apply a slaveholder mentality. We as a court have to consider the rights of all people, including descendants of former slaves, and protect their rights. So we're going to be a little bit more expansive in the way we look at things, and we're going to, you could say, update the Constitution. That's the argument they make is that unless we do that, there's no protection for minority rights. We as a court have to be activists, and it is a reality that it has become so hard to amend our Constitution. Most people don't even think about doing that. Mm-hmm. Sometimes I hear a student say, for example, why would the court restrict the so-called abortion rights when everybody's for them? The easy answer is, well, everybody's for them, then amend the Constitution. So a living Constitution approach says, we will update the Constitution, we will protect individual rights against government encroachment in this kind of expansive way, whereas the originalists say, but that's not our role. It's not just for this group of Ivy League law school graduates, brilliant minds, but it's actually for the people themselves to make that decision. The truth is that rarely does a justice say, I am an originalist, I'm a living. And even for those who do, seem to represent that, like Justice Scalia was known for that. You can find times when they modify that approach, but the disagreement is really about what is the role of a judge. Not so much what the policy choice is that a judge would make, but should I actually even be deciding this case?
There could be an argument if we assume that the major function of the law and of a constitution is to ensure the stability of the legal system and to ensure the stability of relations in a society, that the originalist argument is actually the essence of the law itself. How do you approach this, that there should be stability on one hand, but there should be a little bit of flexibility on the other hand? Is this the same question, or is this somehow a different question?
No, I think that's exactly the same question. There's a phrase that I like. It was used by others some time ago to describe what's going on here. It's called the delicate balance. Mm-hmm. That on the one hand, you have to be true to the enactment process, to the amendment process. On the other hand, you have to act as a judge and protect individual rights. And in one way, when you have a court that's split and you have different points of view in each case, you get that delicate balance. And hopefully it stays balanced, and it only shifts when there's more of a consensus among even both of those. Mm-hmm. And if it's not, if it sounds like it's just this point of view against that point of view, and it's just a vote of the court, then you can. That's when questions can arise about the court having really too much say.
Mm-hmm. It's interesting because the same actually questions, the same issues are raised in the European legal framework, but just that some of the terms that are used are different, and some of the tools that are used are different. For example, one of the tools used by the European Court of Human Rights in order to legitimize its sometimes allegedly too activistic role is the so-called the concept of the European consensus. So the court actually looks at the comparative material, at the comparative sources, whether the substantial number of the Council of Europe member states went to some goal in adopting the legislations. And then based on that, it could tell that there is or there is no consensus by the member states, in this way somehow expanding the notion of the abstract right. So it is also like the European Court of Human Rights tries to also search for the ways how to maintain the European Convention functional, and tries to really search for the legitimate ways.
That's very interesting, and it sounds to me like the closest analogy in our Supreme Court jurisprudence is in the U.S. consideration of the death penalty. This is the one issue where you sometimes see the court, some members of the court, even wanting to look to international examples. And in the recent death penalty cases, the Supreme Court talks about just what you described. They've said, what is cruel and unusual punishment? That's what the U.S. constitutional issue is the death penalty a cruel and unusual punishment? And they look to the number of states that do it, the number within the United States, counting them, giving them as examples. And some justices say, well, we should also notice that the United States is a little bit alone on this when we look at some of the similar legal traditions to ours, and we're still doing it and they're not. On the other hand, there's some justices, Justice Scalia among them, who said, we don't really care what other countries have to say about this. It's our Constitution that we're interpreting. We're not looking for that kind of consensus that you described.
That's interesting, really. So let's go to the particular cases right now. And we have one exceptional case, the famous Dobbs versus Jackson Women's Health Organization, a dividing judicial opinion that changed the famous or infamous Roe versus Wade doctrine on the right to abortion. So while discussing with lawyers, sometimes I am asked, and I hear the opinion that actually this judgment forbids the abortion in the United States. Does it forbid, really?
Absolutely not. That's not at all what the court said, and they were very clear in saying that it was not their role to make that decision. That's really what the court was saying.
So could you put this decision in the context of a debate among originalists and the proponents of a living constitution?
Sure. It follows that case I mentioned earlier, Griswold versus Connecticut. Griswold versus Connecticut was a case involving a state law that made it a crime to administer contraception or to advise someone about it. 1965, a long time ago. States were not doing it anymore, except for a couple of examples, but this was a time of increasing attention to women's rights and some social issues. And the court, in a very strange opinion, the majority opinion said that there is a so-called right of privacy that the government cannot invade. And that was an example that's usually given as one of the foremost illustrations of the living constitution idea. There's no mention of a right to that kind of contraception or advice. There was nothing the judges could agree on to point to in the Constitution for that right. And the majority described it as a kind of privacy right that falls from a penumbra of the Constitution, just something that we feel. And other justices were so uncomfortable with that, and no one actually agreed with that reasoning. Some said it was based on due process. Some said it was just an absurd law because it only applied to married couples and didn't really achieve any objective with them. Others said that it was the Ninth Amendment, it was another right. But the so-called living constitutionalists were having all different ideas about how that came about. The dissent said, why are we overriding the states? This is a social question. It always has been. We've never decided this before. We've never been asked. This law has been in Connecticut for year after year after year. It goes through the legislative process. The legislature chooses to keep it. So we as a court shouldn't sit here and overriding that. That became the basis for Roe versus Wade, which was the case in which the Supreme Court said that the government could not entirely restrict abortion because there was a woman's right of access to abortion. But they said the government still had an interest in regulating abortion. But the court really didn't talk much about the child, what the court calls potential life. It's about the woman's right, the government's interest. And in Roe versus Wade, they came up with this formula of trimesters that in the first third of the pregnancy, you couldn't forbid the abortion. In the last third, you could because the child was viable. And to kill the fetus was similar to killing a person. And then they kind of just had some vague information about the middle. So the states went all about adopting different rules on that, always having to be careful about the idea that you couldn't interfere with the first trimester right. Over time, that whole idea of trimesters, when the life is viable, it no longer was valid. All judges agreed that the details of Roe versus Wade were problematic. Children were viable at earlier times in their lives. Medical procedures. What medical procedures had changed? The way that decisions should be made, the way that the potential mother should be counseled, the right of the father to be informed or participate. All these issues, the courts were struggling with how to deal with that. And where we arrive with the Dobbs case is the Supreme Court, in a case written by Justice Alito, said there is no right to abortion. We don't, going back to Griswold, unlike this right, we don't find it anywhere in the Constitution. And in fact, it really doesn't make sense to say it's a fundamental right because throughout American history, it had been restricted, that these laws were allowed. It was only in Roe versus Wade when the court, as the Dobbs court said, kind of jumped out of the whole track and invented this new idea. The court sat there saying, well, we now are going to recognize a right. And Justice Alito said the court did that when there was a policy debate going on in the country and states were already changing their laws. At the time of Roe versus Wade, there were, I think, 30 states that restricted or prohibited abortion, but that was changing over time. And he said, well, why was it that the court decided that no longer should the states make that decision, but we should? Maybe one justice, if it's a 5-4 decision, decides that whole very difficult, complex issue of a right to abortion. So he said that that case, that Roe versus Wade, just was bad law. It didn't have a basis. It was contrary to the prior law, and it left things so unclear. He said also that in addition to this difficulty of what was the validity of the case, it wasn't a workable one. That the states didn't really know how to apply that rule. The trimester didn't work anymore. And so to keep that case and to say it's still valid just left everyone confused about what the law was. And then I think the most difficult part of it was the question of reliance, stare decisis. It's very important in the common law system for courts to be consistent and predictable. You said that earlier. And so when does a court overturn something it's already said? And in this case, Dobbs, the court said, well, we do that. A big example of that was a case I'm sure you're familiar with, Brown versus Board of Education, segregated schools. In the 1950s, the court overturned its prior decision that said school segregation was valid because they'd learned about what the effect of that segregation was. And it pointed to other cases where the court departed from its precedent and was willing to change. And the court Dobbs said that here, this idea of reliance on Roe versus Wade, the problem was how is the court to make these judgments? There is the issue of the woman, which the court says is a very important issue. They did not say we have no concern about women in this. They said that's a tough choice. The court also said that the rights of the potential life also have to be considered. And remember what I said a minute ago was the mother's rights and the government, but now the court's saying, but there's also potential life. And Roe versus Wade didn't talk about that. So if you're going to try to weigh all of those very important issues, what Dobbs says is not the court that should do that. That's a policy decision that is better made in the states. And different states might decide it differently. It might depend on the determinations that come through the legislative process, on the will of the population. And the court really said this is not that there's no right to abortion, but that's a decision that should be made in the political process rather than by this court.
So it is basically about who is actually responsible for what question. So it is about a discretion of political powers, as far as I understand this. Would you say that if Roe versus Wade is an opinion not 5-4 but 9 or unanimous, would it change the reasoning? How much the factor is that the decision is unanimous or not determine the willingness of the judges to change the doctrine?
That's a really good question, and I think there's something to that, that the fact that there has been disagreement among the judges certainly weakens the strength of the precedent. Something that I was very interested to see in Dobbs was Justice Amy Coney Barrett, who, when she was going through her confirmation process to become Supreme Court Justice, she talked about something called super stare decisis, where certain cases have become so well entrenched in a society that even if the current court might otherwise decide the case, they shouldn't. And she gave as an example of that Brown versus Board of Education. She said that why wouldn't the court ever overturn that case? Because it would never make it through the courts. If you as a litigator went and tried to challenge it to a judge in the trial level, the judge would say, they're going to overturn that case. That's a foundation of our law for the last 70 years. She mentioned that. She didn't mention Roe versus Wade. And when they asked her about it, she just kept describing the idea without saying, I wouldn't overturn Roe versus Wade. She joined the majority in this case, but she didn't say anything about that. But what I did notice in the opinion is the court was very careful not to say that they were doing anything to overturn Griswold. So it seems like they had to get her to agree to join by saying, this is as far as we're going. Roe versus Wade, as you said, is a case that from its beginning caused a lot of disagreement and anger. And therefore, that's more of a reason why, rather than change the decision as a court, we should back out of making that decision. And so it's not being decided based on a 5-4 majority of who happens to be sitting at the court at the time.
We actually touch the judicial activism as a really difficult concept and a challenging notion, and so many debates are around the question whether the courts went too far. And we have this, as I told earlier, the same in Europe, asking whether the Court of Justice of the European Union or the European Court of Human Rights acted actually within the discretionary limits given by foundational treaties. Here, let's turn maybe to more particular practical questions related to the sources of constitutional interpretation. It is also related to the same debate about among the originalists and the living constitution proponents. And here, there is a very famous debate. It's not the only debate among former Justices Stephen Breyer and Justice Scalia about the status of foreign court judgments as the sources of constitutional interpretation. And here we also have a really interesting developed doctrine of the Lithuanian Constitutional Court during the last decade that not only refers to the judgments of foreign courts as a legitimate source of constitutional interpretation, but also refers to the soft law sources while applying the Constitution. How would you approach this, referring to soft law sources in the light of the United States Constitution?
Yeah, you do see references to academic literature on occasion, more as when the court is trying to show there's some sort of consensus of viewpoint. Never really giving it authoritative status, but as showing that there's agreement on this issue. even that, many justices don't even think that should happen, that it's really a matter of its own precedent and its own reasoning. And again, it's the disagreement at how far does the court go in interpreting something literally or updating it in modern times. There's, the disagreement between Breyer and Scalia comes up most often in those death penalty cases, and there's just outright disagreement. Scalia's view is that in our Constitution, there is no supranatural or overriding human right concept. Everything is the consent of the governed. Everything is expressed in the Constitution. And whatever the court decides is always subject to being overridden by amendment of the Constitution. So the fact that another country might think something isn't for the court to apply to update the Constitution. If anything, it would look only internally for that. There is, though, an interesting aspect of what you mentioned as soft sources. You may be familiar with Richard Posner, the Seventh Circuit judge, and he's got a very interesting book called How Judges Think, and he's commented and written about this idea of what is it that the advocates should bring to the court to help them decide cases. His interesting point is, I don't really want to hear your interpretation of cases. We can do that ourselves. We want really social science. We're judges who work in chambers in Washington, D.C., who don't even interact with the population. They don't have scientific training. They don't have social sciences training. So bring to us data, bring to us the science, and that helps us then interpret the law. And an example of that was the Brown versus Board of Education. If you read that opinion, it's all about the effect of segregated schools on children and how it makes them feel. And the court said that we've learned now through this research that this was a bad decision. So Posner is saying that's how you should be helping us, not just one advocate saying this case means that and the other advocate saying that, and we choose a side. Bring to us things that we don't already or aren't already able to do. And that could include the perspective, the international perspectives and the decisions of other courts. If that's the kind of discussion that's going on there, then I wouldn't know why that wouldn't also be relevant.
So basically, this is the consequentialistic argument. So we could look at the outcome of a decision or of a policy and decide based on that, isn't it?
Absolutely.
Right? Yeah.
Yes.
So it's, do you consider the explicit references to the soft law sources or foreign court judgments in the U.S. Supreme Court judicial opinions as a legitimate way of legal reasoning, or should, as Scalia once pointed, that you could read about foreign court judgments, but you shouldn't cite them in the opinions?
Not being a judge, I'm not sure.
Yeah,
but it would, if I were a judge, I would think if I'm relying heavily on something that's informed me, it would be good to let others read that too. I don't think it undermines the fact that you're making the decision. I don't think it undermines your credibility. But apparently, maybe the fear is that we lose sight that what we're really interpreting is the U.S. Constitution, not a worldview of human rights or law in general.
In one of the recent articles that you written with Emily Roscoe, you underlined the importance of a comparative outlook of American law students and lawyers. And this is also related to what we started to talk about, how much the judges of the Supreme Court should actually include the foreign law in their judgments and considerations about the European countries or other jurisdictions. Would you consider in general that the knowledge of law from other jurisdictions is anything more than simply a willingness to learn from others and simply just broadening your own perspective about the world?
I think most judges would say that that is the case. It's just personal enrichment. At least that's what they would say out loud. But I would say there's a couple of other ways of looking at it. We all have a perspective, and we see extremes, and we see places we wouldn't want to go in our interpretation. But most issues have some aspect where we're in the middle trying to make the decision. By looking at comparative law, by looking at other examples, I think you recalibrate that spectrum a little bit, and helps you maybe see where that middle might be, or where the acceptable ground. If there's an example of this in a place like Lithuania, where we have currently very similar outlooks to the constitutional law, at least in some very important ways, and given its different legal traditions and experiences, looking at that helps put things in perspective with maybe ways we haven't looked at it before, but yet could be the same issue that we face. It may show that maybe we're being a little bit myopic in looking at it. And I will say personally, by looking at comparative law, I've learned to greater appreciate some aspects of our law, which then makes me more careful about protecting those things. Freedom of speech is one. We have generally, I would say, a very liberal view of freedom of speech in the United States, that most anything is protected, at least in the courts. But we also have some popular opinions that think certain speeches are unacceptable and should be silenced. And there might be some that are willing to accept those kinds of restrictions. But if you look at examples, things that are going on in the world today, you might see how dangerous that is. So you could be oblivious to those risks in your decision and be more careful about how you approach freedom of speech issues when you keep those examples in mind. We have them in our own history too, of course. If you look back in history, examples where those same types of issues arose. But the current world is very different than it used to be. So I think that broadening perspective is helpful in both of those ways.
So you would say this is quite practical to have American lawyers to be exposed more to international law and to law of some other nations. Does it really give something additional to their ability to practice?
In my opinion, absolutely yes. And I would almost say it's increasingly important, given the way the world has changed and how much smaller the world has become.
So my probably last question here would be related to the course that we will be sharing next spring, current public law topics in a comparative perspective, Europe and the United States. So with the students of the University of North Carolina and Vilnius University School of Law. So we will be giving this course, and there will be students from both jurisdictions. What message do you have for those students who are considering applying to this course, and what could be their expectations towards this course?
It's interesting when you ask that question. I think the last answer I gave about broadening, it fits perfectly. Maybe you realize that. Yeah. But I'm also on this how excited I am that I'm going to get to work with you on this course and with your university students. But I think there's a number of different ways that students can look at this as being beneficial. Of course, my students' ability to learn from you and about that broader perspective is going to be important. And I hope that the same will be true for students here who will hear from me and my experiences teaching Americans. So there's that broadening. I think the students will have an opportunity to learn a lot from each other, what their different perspectives are. I think they will find that the American students will be a diverse group. They will be arguing with each other and bring different regions, different upbringings, different economic circumstances to the discussion, all students, I think, will learn from each other by having an even broader expense of that. And as you know, we're also going to teach the course using the Socratic method, engaged dialogue. So it's not a typical way of teaching. I think for most students, they're more familiar with lectures and other types of teaching. And here we're going to be engaging them in an engaged thought process. And I'm really fascinated to see how my students will engage with you, and hopefully how yours will with me.
Yeah, great. I'm really looking forward to the start of our course next spring. And thank you so much for taking your time. It was really a pleasure to have you here. And I hope it's not the last time we're talking about such great questions and such really deep topics. Thank you so much.
Thank you. I look forward to continuing to work with you.